Um, Your Honor, may I please check with Mr. Fortis about something?
Sure, go ahead.
Mr. Fortis, was this an incident date from July?
Yes. July
Um,
18th of 2022.
I believe it started in the solicitor's office.
Okay. Yeah, and it was upgraded.
Please accept my apologies, Your Honor. This one does not appear to have been created within our office's internal system.
Is he having to pay for it, Mr. Fortis?
I'm not 100% sure about that, Your Honor.
All right, hold on. Odyssey's a little bit slower coming up. Bostic said her computer froze. She should be back in a second.
Your Honor, my concern, speaking on behalf of the state, is that the defendant would, if the ankle monitoring requirement was removed, that the defendant would then make contact with the victim as well.
Your Honor, with all due respect, he's the victim. She stabbed him. So she was arrested for aggravated assault arising out of the same incident. So I don't think there's going to be any contact by either one of them. But my understanding is that the purpose of the ankle monitor was for the residence, which is an apartment, which has been vacated and the lease has been terminated. So there hasn't been any bond violations in the last 6 or 7 months. I don't anticipate there being any, and all the other conditions of bond would remain. But if anyone's the victim in this case, it's my client.
I guess both people can be the victim.
Sure.
She stabs him, he chokes her, right? You know, mutual combat, right? Mutual
So they
combat.
say.
So he lives.
Judge, I do see that it was county funded, that ankle monitor.
All right. So does he live in Clayton County? I mean, excuse me, Fulton County?
Hang on, Judge. Let me get your address for you.
I don't think he lives in Fulton County.
He lives in Gwinnett County in Lilburn.
Good. He can stay out of Fulton County, can he?
Yes, Judge.
Unless he's here for court, lawyer. He can stay out of Fulton County. Let's see. What's it? We'll remove it. You give you the order, he can take it off March 1st. How about that?
That's fine, Judge. Thank you.
All right. Have a go, Mr. Fortis. Enjoy the game. You gonna shoot me the order?
Am I drafting it? Typically they draft them. I don't have any problem drafting it.
Yeah. Y'all have to draft the modifications and just send them in. You can send it right to me, and I'll get it signed and shot back to you. And you can send it to the jail.
And Judge, would someone just send me your email address in chat, please? So I have it.
Okay.
Okay.
All
And I'll
right.
sit down until I get that. And then I'll go ahead and draft it and send it over.
Okay. Miss Wells. So we got Richard Grayson, position 622 CP 208904. Richard Grayson. This is a false imprisonment. Go ahead, Miss. Is Bostic back? Oh, Bostic. I wonder if it's her on her iPhone. Go ahead, Miss Wells.
Your Honor, this was an incident that occurred in early May. Husband and wife with small children, able to pick up the children. It may even very well be part of the no
Handling this one. And if she is present, we would like to hear.
Good evening.
Thank
too.
you.
All right, and we got, let's see, Scott Colbrand, 22 CP 214282, aggravated stalking. There's a $25,000 good bond.
Yes, Judge. Attorney Scott Smith on behalf of Mr. Colbrand. This should be very quick.
All right, go ahead.
Thank you, Judge. Original bond order provided that it's a special condition. He stay away from the entire complex, and he must enter into the Sunrise Detox Facility up in Alpharetta. He entered the program, successfully completed the program. He's now moved on. He's now been admitted into the Florida Recovery Group. So we just wanted to let the court be aware of that. I think he satisfied the condition that he entered into the program. He completed the program. But maybe if we can modify the bond order, I submitted a proposed order to permit him to enter into the Florida Recovery Group successfully complete that as a special condition of his bond. He's happy with that. He's currently in the program. He's doing well. We're also asking that he be permitted to have the ankle monitor removed as the condition of his bond was the original ankle monitor, but not returned back to Fulton County. He has no reason to come back here. Except for
Yeah, is
one.
it you, Ms.
Except for-
Amjadi, or is it? Oh, I'm sorry, go ahead.
No, except for lawyer and court purposes.
Mr. Wittenhauer, I know this was just done in November.
Yes,
You're
Judge.
on to, removal of an ankle monitor.
So he's wanting, you still got to stay away from the complex. He just wants to move to another treatment facility, Mr. Smith?
Yes, Judge. He's already there. So technically, if you were to read the bond order only says that he has to enter in the Sunrise detox, which he did, and he satisfied the condition. But I'm letting the court know that he's moved on to another facility because he graduated from there. It's only a short-term facility, and this one is a longer-term facility that he's currently at, which is called the Florida Recovery Group.
Mhm. I mean, that's absolutely, I mean, that's fine if you want to send that modification, but I'm not going to remove the ankle monitor. You just got this on in November.
Yep,
And
fine.
it's aggravated stalking.
Judge, do you have access to our motion and proposed order? If not, that's no big deal. I can resend it.
Yeah, you have my email, right?
No, if you don't mind adding that to the chat, I apologize.
All right, let's see. Mr. All right, I'll add it to the chat. Or Ms. Robinson, can you send it to Mr. Smith and to Mr. Fortis both for me, my email?
Yes, Judge, I already sent it to Mr. Fortis. I'll send it to Attorney Smith right now.
Thank you so much. All right, so he's gonna keep on the ankle monitor, but he can move. So you just send me that. Free.
Okay. Thank you, Judge. And I do appreciate your speed.
Okay, let's see. Do we have Benjamin Charles, Mr. Stephen? It's 22 CP 212243. Benjamin Charles, it's aggravated assault.
Yes, Your Honor,
Go ahead.
Stephen Roberts here for Mr. Charles.
Hey,
you hear me?
whoever this Cortez Harvey is, stay on mute. Kick them out of there. Just kick them out. They can't stay on mute. Kick them out. Go ahead.
You ready for me, Mr. Judge Manning?
I am. Go ahead.
Stephen, okay. Your Honor, this is a married couple. My client, Mr. Charles, and his then husband, Jordy Rivera. They got into a fight and an argument at their apartment they shared on Howell Mill Road. For some inexplicable reason, they had essentially the same injuries, a cut to the face. My client was charged with aggravated assault. He was charged with simple battery, family violence battery. They both had a no violent contact, stay away from the residence of the other. But my client actually is on the lease at that address. His bond, my client's bond, specified stay away from that location, Howell Mill Road. The other party, Mr. Rivera, has moved out. His attorney has told me he has no intention of going back there. My client has rented another apartment in that complex. They're both in agreement to stay away from each other. It's just my client, for some reason, his bond says stay away from the address, and the other gentleman just said stay away from my client's residence. So it makes no sense since my other client, the other subject, that is Mr. Rivera, they essentially had the same bond conditions. For some reason, there were two separate judges and two separate hearings, and my client had the address specified. My client lives there. Mr. Rivera has moved, and his attorney has told me he has no intention of ever going back to that location or that address. My client wants to just take the address out and keep the conditions of stay away from the other's residence, which they're both fine with. So it just needs to have the
Ms.
address.
Amjadi? Ms. Amjadi?
Your Honor, no objection, Your Honor.
Okay, thank you.
All right, just send me the modified order, okay?
Judge, I'll send it to you. Now, do I need to go into a chat room to get that at the email address for you, Your Honor?
Ms. Robinson will put it in the chat.
You'll put it in the
I'll
chat.
send it to the attorney. Yes, sir. Yes,
Okay, and I will send that modification to you. Thank you, Ms. Ajani. Thank you, Your Honor. May we be
All
excused?
right, have a good evening.
Thank you.
Yes, sir.
Your Honor, good afternoon. Is the Spanish interpreter going to be needed today?
Yeah, yeah, her email.
Do we need the services of the Spanish interpreter? Anyone? Anyone? Thank you, Ms. Jarvis.
Mr. Perea, do you need a Spanish interpreter? You're good, right? Okay. No, we're fine, Judge. Thank you, Honor.
All right, thank you, Ms. Chavez. Give me a free
Welcome,
trial,
young.
Ms. Chavez. Give me a free trial. Come on, try it one more time.
Los servicios de pretrial.
All
Bye, Your
right, Ms.
Honor.
Chavez. Have a good one.
Just a minute, Your Honor. I have an announcement.
Go ahead.
Gentlemen, all y'all that are in for Zoom court, I need you to pull your doors up. I need you to stay in your booths until your case is heard. The judge cannot keep a monitor on you guys going in and out of the door. So please stand by, wait till your name is called, and go from there. Unless the deputy from the outside has called your name. Thank you, gentlemen.
Thank you, LT. All right, we'll go down to ACDC. So we got Chantel Daniel. Well, that's Mr. Melnick. Are you here yet, Mr. Melnick? Oh, well, Mr. Melnick's he's 2. All right, what about Ms. Hemingway?
No, we don't have Hemingway, no.
I just saw Hemingway.
Oh, I'm sorry. I thought you was calling another female.
I'm calling the lawyer. I don't see Hemingway. We'll try to get in a minute. All right, let's see. Everybody down there, Miss Rondon, I mean, everybody, the lawyers are late. So could you just stand by ACDC until they get by? I'm sorry.
No problem.
All right, let's see. What about Lathera Birch? Lathera Birch, wave your hand if you're here. Birch.
Judge, Delisa Williams for Mr. Birch. Good evening.
How you doing? Well, it looks like Mr. Birch isn't waving his hand, so he must not be there.
That's him, Judge. He maybe can't hear, but I see him. Booth 4.
Latheria Birch, raise your hand. Birch.
I think that's him in booth 4, Judge. Maybe not.
All right, let's move to somebody else. All right, Mr. Shaw, how about Mr. Perella, Louis Perella? There you go. All right, Mr. Shaw, this is position 24, Bostic 22 CP 212-510, 111 days without indictment. No bond as of September the 21st. Louis Perella, conspiracy to commit a felony, possess or have under control a counterfeit substance. Pre-trial. Bostic.
Sorry, hard to find this button on this little bitty phone, Judge.
Go ahead, Bostic.
Can you hear me?
I can.
Okay, Louis Perella. Judge, he had his prelim this morning, 3 prior arrests in New Jersey. Parole, criminal sale of controlled substance started 6/13/22, ends 11/20/2023. 11 arrests for distribution, possession with the intent in New Jersey. 6 arrests in New York. Old convictions there are for robbery, criminal possession of a weapon, and forgery of an instrument. Nothing further.
All right, looks like on here, Mr. Shaw, there were 3 kilos of fentanyl or cocaine. Go ahead, Mr. Shaw.
Allegedly, Judge, and it actually turned out not to be those substances. That's why he's charged with counterfeit of those substances. Judge, as you heard, he did have the preliminary hearing this morning, and it was with Judge Wanda Dallas. And I quote Judge Dallas, Your Honor, from this morning, and she said, the state just barely proved probable cause, and she was about to dismiss the case this morning, and she didn't, just for a smidge. Your Honor, in addition to that, the co-defendant in this case, who is sort of the mastermind of this whole scenario, has a $5,000 bond, and he's out in general population, Judge. Mr. Perella is a U.S. citizen. He's been living in this country for 20 years. And as you know, Judge, he's been in custody for 114 days. So he is entitled to a bond under law. But I'm also asking for a very reasonable bond, Judge, at the very least, no greater than what the co-defendant has been given, a $5,000 bond or less. He has 5 children, Judge, a 2-year-old, a 9-year-old, two 14-year-olds, twins, and an 18-year-old. He has a wife who's been doing nails, and she makes about $500 a week. Mr. Perea, I think I'm saying his name correctly. Mr. Perea does framing for like housing and construction and that sort of stuff, Judge. And he makes $11 an hour. And his wife indicated that she's spoken with his boss. If he were to be released, Judge, he would still have that job available and he would go back to work. And his wife desperately needs him to be out so that they can take care of these 5 children, so that she's not working and dropping them off at school and providing for them, and Mr. Perea can contribute towards that. Other than that, Judge, I would just ask that the bond just be at least $5,000 or less, no more than that. I don't think that Mr. Perea is a threat to society. He's not a flight risk, Judge, and I think anything more than $5,000 would not be necessary to ensure his appearance for his court dates.
Is that is it Henry Romero? Is that the co-defendant?
That's right, Judge.
Okay. Ms. Amjadi, where's he going to live, Mr. Shaw?
He's going to live in Greenville, South Carolina, where they have a permanent home. And I'm not sure if the state has an objection to that, but if the state does, then we can figure out residence in Georgia. But we would prefer that he live in South Carolina with his wife and his 5 children. And we can provide an address for that as well.
Ms. Amjadi.
Your Honor, the defendant only has 1 criminal arrest cycle out of the state of Georgia, and it's this one. He does have a number of other arrest cycles along the East Coast. He has 6 arrest cycles out of New York, the most recent of which is June of 2022. There's also some drug arrests out of New Jersey. Your Honor, the state's concern here is that the defendant appears to have a number of drug offenses in his history, and these offenses are occurring along major travel corridors along the East Coast. The defendant, for those reasons, the state's position is that the defendant poses a risk of reoffending. State arrest cycle out of New Jersey from 1984. For that reason, Your Honor, the state would respectfully request that any bond the court is inclined to give be accompanied with ankle monitoring, and given the defendant's ties to other states, some sort of reporting requirement.
Judge, 1984, that's older than
you, Mr. Shaw.
Yes, Judge.
All right. No drugs unless prescribed, no alcohol, no weapons. Stay out of Fulton County, sir, unless you're here for court or to see your lawyer. And have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical. Is he going to get a job up there? A good, clean, legal job? Mr. Shaw?
Mr. Perea, she's asking you a question.
Thumbs up or thumbs down? Going to get a legal job, sir? Thumbs up or thumbs down? Like, you're on mute. I need a thumbs up or a thumbs down. That's what I need. Perfect. It could be employment, but he's got to let you know the name of his employer, give you a schedule, proof of employment, and if he's not working, he has to be home. No further contact with Henry Romero. Like I said, stay out of Georgia. So that means, sir, when you come back for court, fill up with gas in South Carolina. Drive real slow, get good gas mileage so you can make it to Fulton County. Don't stop again. If you stop for gas or have a flat tire, that's a violation of your bond conditions, sir. Since you've got a for escape, I'm going to make it 10 and 5. 10 count 1, 5 on the second. Best of luck to you, sir. You can leave the booth.
Thank you, Honor. Pleasure to see you, Judge, if I may be excused.
Yes, sir. Go enjoy the football game.
Thank you, Honor. You as well, whenever you get ready.
Judge,
All right.
Delisa
Yes, ma'am.
Williams, I don't believe my client can hear, Judge. I've seen him go in and out of the booth and I've tried to contact him.
Judge,
but
if he's in if he's in 2 North booth 4, he's gonna move to another booth once the inmate comes out of 2 North booth 2. Once
Thank
another
you.
comes out, he's gonna move to another booth to be able to hear the hearing.
All right, Miss
you.
Rhonda, you're here, Miss Rhonda. That's all. Miss Rhonda.
Yes. Hi, Judge Manning. I'm here.
Oh, how you doing? All right, let's see. Nina Wilson. Let's take care of these over here to City of Atlanta. 22 CP 210980. That's position 20, 168 days without indictment. Charged with aggravated assault. $35,000 good bond as of July the 27th. Pre-trial.
Judge, in regards to Nina Wilson, 10 prior arrests, prior probation violation. She has a prior aggravated assault conviction back in 2005 and 1 conviction for obstruction. Nothing further.
All right, Miss Rhonda.
All right. Miss Wilson is 41 years old. She has been in the Atlanta area for 22 years. I believe she has a good address on file. She is a high school graduate. She does have 5 kids, ages 15, 17, 18, 19, and 24. She was not working prior to her arrest. She does receive disability. So for that reason, we would please
35K. If your honor is inclined to reduce bond, we ask that it be no less than 25.
Where's she gonna live, Miss Rhonda?
The address is 3254 Desert Circle, apartment 1.
Is that in Atlanta?
It is in Atlanta, yes.
All right. We got no drugs unless prescribed, no alcohol, no weapons, no further contact with Cody, C-O-D-Y, Stanley, common spelling. Stay away from 3816 Washington Road in East Point. That's a Chevron gas station. Gonna have an ankle monitor with a 24-hour curfew except for court, lawyer, and medical. $20,000 good bond. Best of luck to you, ma'am. Let's see, Mr. Melnick didn't get here yet, right? What about?
I apologize, Judge Manning. Did you say 20?
Uh-huh.
Okay, thank you.
What about Hemingway?
Is this for Heather Fulbright?
Yes, you gonna do that one?
Yes, I am.
All right, Ms. Fulbright. All right, this is 1422 CP 210457. Heather Fulbright, 193 days without indictment. You got $14,500 good bond as of July the 7th, 2022. Aggravated assault, strangulation, obstruction of law enforcement officer, misdemeanor obstruction, another obstruction of law enforcement officer, and simple battery against a police officer, police dog, correction, or detention officer. Pre-trial.
Judge, in regards to Fulbright, 8 prior arrests, FTA in 2020. In North Carolina, she has a prior larceny and arrest for probation violation. Open case, simple battery, criminal trespass, damage. Victim, Kiera Hudson. Nothing further.
All right. Go ahead, Ms. Rhonda.
All right, Miss Fulbright is 40 years old. Her mother lives here, and the address that she would stay at would be her mother's place. That is 330 Washington Street here in Atlanta. She does have 1 son who is 18 years old. She has her associates in business from Central Piedmont Community College in North Carolina. There are some MH issues here at play, and our office is working to get those needs addressed. We are asking for a reasonable reduction in the bond amount currently set, as Ms. Fulbright is indigent and cannot post the $14,500 bond as it currently stands.
All right. Is this Amjadi or who's got this one? Schwidenauer?
Hi, Judge. I don't have this one marked as mine, but I'm happy to step in and provide you.
I apologize, Your
There she is.
Honor. I didn't mean to put Mr. Whitenauer on the spot.
That's okay.
Which position is this?
Position 14.
And I apologize to Mr. Whitenauer. I had this marked as DV by mistake. Your Honor, given the seriousness of the offenses, I understand that Ms. Fulbright is entitled to a bond at this time, but the state would respectfully request that any bond the court grants be commensurate with the seriousness of the offenses, given the number of obstruction charges here, as well as the strangulation one.
And it looks, okay, so this was with another inmate. Is this somebody, Miss Rhonda, that she knows?
No, Your Honor.
Okay. All right, no drugs unless prescribed, no alcohol, no weapons. I'm gonna go ahead since, I don't know if Miss Corman, is Miss Corman still in jail? Miss Fulbright? Just give me a thumb, yes?
Yes, Your Honor, she is.
Oh, she's still there, okay, so we'll leave it as no further violent contact. You have an ankle monitor paid for by the county with a 24-hour curfew except for court, lawyer, medical. Does she need it for work also?
I'm not sure at this time.
You gotta try to get a job, ma'am?
Yes, ma'am.
Okay, work. You have to supply the name of your employer, proof of employment, a schedule, and the exact location you'll be working. If you don't supply that, you can only leave for court, lawyer, and medical. So I'll reduce count 1 to 5,000, count 2, 750, count 3, 750, count 4, 750, count 5, I'm gonna leave it 1,500. 5,000, 750, 750, 750, and 1.5 thousand. Best of luck to you, ma'am.
Thank you.
All right, hold on. So Mr. Melnick's not here yet, right? Sorry, South Annex, aka ACDC now. No, Mr. Okay. All right, let's see. Lathera Birch. Wave your hand. All right. Position 13, 22 CP 212675. 105 days with no indictment, no bond as of September the 28th. Theft by deception. Lathera Birch, B-U-R-C-H. Pre-trial.
Judge Birch also had prelim this morning, extensive history, currently on probation, Schedule 1 substance, sentence 5-10-21, 1 year confinement, 4 year probation. In Cobb County, 3 other felonies, CWAC, a robbery, simple battery against a peace officer, simple battery and family violence. 02 somewhat CWAC, 4 misdemeanors, 5 arrests for probation violation, 1 arrest for parole violations, couple of FTAs, 02, 14, and 15. Nothing further.
All right. Go ahead, Ms. Williams.
Judge, this morning it came out that this theft by deception is about $300, which makes this a misdemeanor case as opposed to the felony that's listed on the no bond order initially. Mr. Birch has been incarcerated since September 27th. We are asking, so he is entitled to a bond, but we're asking this court for a reasonable bond, in that a high bond is the same thing as no bond in Mr. Birch's case. He does not pose a significant risk of fleeing the jurisdiction. Judge, he born and raised and lives in Fulton County. His entire family, friends, community is all in Fulton County. In regards to the Ayala factors for posing a significant threat or danger to a person in the community, although he does have a history, I don't think that there's any recent history, Judge, that would indicate a threat or danger to society. His last case, the one that was just mentioned in pretrial, was over 4 years ago. This case, I think, Judge, will ultimately be determined at most to be an improper eviction and not a theft by deception. So, Judge, lastly, he is no risk of intimidating any witnesses. The alleged victim in this case is not anyone that the police or no one else knows where she is at this point. I believe they testified this morning that she was moving back to Iowa. So Mr. Birch would not be any danger or threat to her. Judge, we're asking for a $3,000 good bond so that Mr. Birch can be released. As I stated before, this is a property case that does not rise to the level of a felony according to the state. I'm told.
So did they reduce? They didn't reduce. They didn't reduce it and send it back
this morning. No, Judge. I'm told that Mr. Birch was initially denied bond because of an FTA. There was an issue, is my understanding, that during COVID, Mr. Birch moved. His case took a long time to come out. By the time it did come where he was supposed to go to court, he had moved and his number had changed several times. This is not a case that he would need to flee from, in that he's already done 104 days on what is a misdemeanor. This court is well aware the purpose of pretrial is to prevent punishment before conviction and to secure the person's appearance in court. There's no indication that Mr. Birch would not do that. And he's a presumed innocent until proven guilty of this case.
Ms.
So-
Amjadi. Nope, I'm sorry. I got you. You said 3,000. Sorry. Ms. Amjadi. I know everybody wants to get out of here and watch a football game. One of y'all went to the University of Georgia and just too ashamed to admit it. Was it you, Ms. Williams?
No, Judge. University of Richmond.
Okay. All right. I see Mr. Herrick up there. Okay. Go ahead, Ms. Amjadi.
Your Honor, I think the $3,000 good bond figure is a fair and reasonable one. I would also ask for an ankle monitor at the expense of the county. Just out of an abundance of caution and as insurance against further reoffending, because the defendant does present a serious risk of reoffending.
All right. No drugs unless prescribed, no alcohol, no weapons. It'll be a $3,000 good bond. No further contact with Dorothy Taylor. Stay away from 232 Forsyth Street. Have an ankle monitor paid for by the county. You can leave your house for court, lawyer, medical, and of course, employment. You just have to tell Ms. Williams, she'll tell the state proof of employment, the name of your employment, a schedule, and exactly when you'll be working, sir. Best of luck to you, sir. Thank you, Ms. Williams.
Thank you, Judge.
All right. Do we have let's see, Ricky Richardson? I got Cortez Harvey. Do we have his lawyer?
I'm here, Judge. Good afternoon.
Good afternoon. All right. Let's see. Cortez Harvey, wave your hand. All right, there we go. It's position 18, Bostic 22 CP 213055. Cortez Harvey, 93 days without indictment. Criminal attempt to commit a felony, aggravated assault, possession of a firearm or a knife during the commission or attempt to commit certain felonies, possession of a pistol, revolver by a person under 18 years of age, first offense, and aggravated battery. Pretrial.
Sorry, Judge. Who did you say?
18, Cortez Harvey.
I ain't gonna turn my lights on now that I have power.
Pay your bill, pay your bill, Bostic, pay your bill.
The whole neighborhood was out. Thank you, Judge. Wasn't just me. No prior arrest, but he does has another open case, 22 CR 0067886A. Pistol by someone under the age of 18 and simple battery on a peace officer. Nothing further.
All right, go ahead, Ms. Richardson.
Judge, my client, 17 years of age, lifelong resident of the Metro Atlanta area. He was attending South Atlanta High School. His mother, who's on the platform now, Ms. Demetrius Harvey, has made arrangement for him to attend the Atlanta Promise Center, which is a new program, or not necessarily really new, but that works with the City of Atlanta Police Department, the Urban League, as well as the GED and high school completion program. She's made arrangements through the coordinator there, Mrs. Williams. His mother works for a company called Innovations Warehouse. She's been there for 4 years. She has 3 other children, one 20, one 12, and one 8 months. That's where he will be living when the court releases him on bond. So she makes above minimum wage, but not enough to pay a large bond. That's the court has set a reasonable bond on this case, in an aggregate of $10,000 or whatever terms and conditions. We'd like the court to make it so that he can attend high school. He's a senior with an opportunity, if he puts the pedal to the metal, to actually graduate on time this year. So we ask the court to set a $10,000 bond and a curfew, and that he attend high school and complete it successfully, at least to the best of his ability. That's all, Your Honor.
Ms. Amjadi.
Your Honor, these are really serious offenses here. I understand that we have criminal attempt to commit a felony on our calendar, but when I look at the warrants, it looks like it's criminal attempt to commit armed robbery. Consequently, the state does have serious concerns about a bond amount. $10,000 appears to be far too low given the seriousness of the offenses that we're dealing with today. Additionally, given the firearm nexus here, I would respectfully request that for any bond that the court is inclined to grant with respect to the firearms charges, that bond be no lower than $25,000. For each offense, with respect to the aggravated assault charge, the state respectfully requests that any bond the court is inclined to grant be no lower than the amount of $20,000. The same for the criminal attempt to commit a felony charge, Your Honor. And with respect to the aggravated battery count, Your Honor, a bond amount no lower than $50,000.
May I respond, Judge?
Sure.
Judge, obviously, the purpose of bond is to assure a person's presence in court. Under the ILL factors, there's been nothing here that indicates that he won't appear in court. Just the purpose, like I said, the purpose of bond is to make sure he appears in court. If the court were to place an electronic monitor on his ankle, the punishment effectively, Judge, would go to his mom. He's 17-year-old. He doesn't have a job. Bond is not supposed to be punitive. He'll be tantamount to no bond. She makes about $14 an hour with 3 minor children. The court places an ankle monitor on him with a curfew, $100,000, an ankle monitor. I mean, the ankle monitor would, with the strict terms that the court can place on Mr. Harvey, will assure his presence. He will be with his mom. He has a specific address. He has no prior felony record. So I asked the court to set, that bond of $10,000 or $15,000 and the ankle monitor with the strictest terms, Judge.
All right, also got this, that it's also posed no significant threat or danger to any person of the community, any property in the community. And according to this, Jordan Wilkins, the backside of his head was partially blown off due to a shot allegedly that Harvey made to the side of his head. So,
and
no
Your
drugs
Honor,
are-
if I may also note one other thing, our defendant is about 17 years old, which may explain the lack of a prior felony record.
All right.
Judge, there's a co-defendant on this case.
Oh, I understand. I got that. No drugs unless prescribed, no alcohol, no weapons, no further contact with Bob Wilkins, Wilkins, no further contact with Jordan Wilkins. Stay away from 377 Decatur Station Southeast. Stay away from all MARTA property, bus stop, train station, anything. MARTA property, if it's where they repair the buses and trains, stay away from there. No further contact with the co-defendants, Marquavius Jackson, Marquavius Jackson. You gotta have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, school only. You're not at school, you're not at court, you're not at the hospital for something, you don't leave your house, period. 24-hour curfew. You must attend school and completed it successfully. Let's see, 10,000 count one. Were both people shot in the back of the head? Allegedly.
I have one, Your Honor, according to the warrants.
Because it said, okay, all right. Do we have the update on how the victim is?
Let me pull up the notes, Your Honor. Let's see. The victim is against any granting of bond, but of course the defendant is now legally entitled to a nominal bond, or I'm sorry, a bond
Right, nominal.
under the statute.
I got you. All right. All right, 10,000. 50,000, 10,000, 20,000, and 50,000. 10, 50, 10, 20, 50. Best of luck to you, sir. And Mr. Richardson, as long as you get in touch with the victim and see what's going on with the victim, I hope for your client's sake and the co-defendant's sake that he doesn't pass away. Best of luck to you, sir. You can leave the booth. Andre Davis. Thank you. Andre Davis. Wave your hand. Andre Davis. There you go. I think we got it turned. There he is. Okay. This is position 5, Bostic 22 CP 213009, Andre Davis, 94 days without indictment, armed robbery, false imprisonment, kidnapping, possession of a firearm by a convicted felon, possession of a firearm or a knife during the commission of or attempt to commit certain felonies. No bond as of October the 8th. Pre-trial.
Judge, in regards to Mr. Davis, only prior arrest was in Michigan in 2016, possession of a weapon. I think it was a conviction, nothing further.
All right. Go ahead, counsel.
Your Honor, thank you. And we would note that we don't have any documentation of a conviction. We actually have documentation of a dismissal for that particular charge. I recognize that he was charged with possession of firearm by a convicted felon, but I'm not sure what the conviction they're using for that is, because the only other arrest was that arrest where we have show of dismissal from. But Mr. Davis is 24 years old. He's been in Georgia 3 years. He came here from Michigan with his mother. However, he has a significant amount of family here, including 2 uncles, an aunt, and several cousins. Both his mother and father are actively involved in his life and intend on coming down to Georgia. When I talked to him yesterday, they were actually on their way here in anticipation of him being released on bond. He does have an Atlanta address in Berkeley Heights. He is a high school graduate with some college. In terms of his work history, he has his own clothing line. He is also a certified phlebotomist. He's actually supposed to start work at a new job the day before he was arrested, sorry, the day after he was arrested on these particular charges. As we noted in terms of his criminal history, what he was charged with was actually having a taser in his book bag at school. I think he was 16, 17 years at the time. And he was able to go and complete a program in Michigan called the Youthful Trainee Act. And I have documentation that I can provide to the state showing that those charges were actually dismissed. Based on the Ayala factors, Your Honor, we don't believe he's a threat to these alleged victims. It's my understanding he doesn't know these people. Apparently there was some online or social media communications with some other individuals, and Mr. Davis' name somehow got caught up into the matter. Obviously, with the limited criminal history, we don't believe he's a threat to reoffend. No prior criminal history other than what we've discussed, and again, not a risk of flight. He has an address here in Georgia that he lives in and intends on continuing to stay in Georgia. We would ask that a reasonable bond be set on all charges.
What's the address he's going to be living at?
It's Berkeley Heights. If you want the specific address, since this is being streamed, I can put it into the
Fulton County?
yes.
Okay. All right. Ms. Amjadi.
Your Honor, with respect to the prior conviction issue, I believe it was a conviction out of the state of Michigan involving a taser. Having reviewed the warrants for both of these cases, Your Honor, with respect to position 5, 22 CP 213009, the state's position is that the defendant poses a danger to the community, a danger to property within the community, and additionally that he poses a risk of harassment and intimidation to victims, something that commonly accompanies charges such as armed robbery, false imprisonment, kidnapping. The state would respectfully request that any bond the court grants at this time not go below the amount of $100,000 for the charge of armed robbery. Any bond the court grants in this case be above the amount of $50,000 for the charge of false imprisonment, above the amount of $100,000 for the charge of kidnapping, above the amount of $25,000 for possession of a firearm by a convicted felon, and above $25,000 for possession of a firearm during the commission of certain felonies. Additionally, we ask that there be no contact with the victim, Mr. Kang Yu.
Your Honor, if I may, again,
If I could just do this, 22 CP 213010, that's the armed robbery and the false imprisonment for Andre Davis. Quickly. I have done my homework, so quickly.
Your Honor, with respect to position 6, 22
Uh-huh.
CP 2 and 3010, we would ask that any bond the court grants not go below $100,000 for the charge of armed robbery and not go below the amount of $50,000 for the charge of false imprisonment. And additionally, that the defendant have no contact with the victim, Rahul Singla.
All right. Okay, what else, counsel? You want to say something?
Yeah, I would just say that, the bond amounts that the state is talking to, we believe would be prohibitive and tantamount to no bond. Mr. Davis, as I've noted, at the time was supposed to start work, but has not been employed. Obviously, he's not been employed in the 3 months that he's been incarcerated. Although he does have a clothing line that would be based on obviously his being out in the community and being able to market that. And we would ask that the court consider a reasonable bond and that the amount that the state has requested is unreasonable and tantamount to no bond. We'd ask for a bond of no more than $25,000 on robbery charges, 10,000 on the kidnapping. I'm sorry, 10,000 on the false imprisonment, $25,000 on the kidnapping charge. And again, we do have documentation, and as far as I can tell, the state is kind of guessing about the convictions for the taser in Michigan, but we'd ask for a $5,000 bond on the possession of firearm as well as the possession during commission of felony.
Ms. Amjadi, any contact with the victim that you know of?
Your Honor, I know that my victim advocate was having some technical difficulties earlier today, so the others were assisting her later this afternoon to try to reach out to them. If the court will give me just one moment.
All right.
Like for clarity, it's 2 cycles on that one arrest. The first notation says the charge will be dismissed with the completion was dismissed. Let me read it exactly how it says. It says dismissed under Holmes Youthful Training Act. And the next cycle thing says what the sentence was.
Okay. Position 5, no drugs unless prescribed, no alcohol, no weapons. No further contact with Kang Yu, Kangyu. No further contact with your co-defendants. Justin Davis, Raquez Thompson, Raqueze Thompson. Stay away from 396 Piedmont Avenue Northeast. Ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, and medical. $50 on count 1, $20 on count 2, $20 on count 2, 10 and 10. 50, 20, 20, 10, and 10. Position 6. No drugs unless prescribed, no alcohol, no weapons, no further contact with Rahul Singla, Singla. No further contact with your co-defendant, Justin Davis, Raquez Thompson. Stay away from 396 Piedmont Avenue Northeast. Ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, and medical. 50,000 and 20,000. Best of luck to you, sir. You can leave the booth. Thank you, counsel. Have a good evening. If you don't have anything else.
Your Honor, if I may, for the position 5, it was 50 on the armed robbery.
All right, here we
20
go. You ready? 50, 20,
Yes.
20, 10, and 10. 50, 20, 20, 10, and 10. Then the other one is 50 and 20.
Got it, Your Honor. Thank you.
All right. Thank you. All right. We have attorney for Jamal Wheeler. Oh, there we are. Mr. Wheeler, wave your hand.
And Judge, I'm here for Mr. Wheeler.
Mr. Wheeler, wave your hand. All right, there he is. All right, 21 CP 205344. Jamal Wheeler, 383 days. Cruelty to children in the first degree, $175,000 bond as of August the 29th. Pre-trial.
Judge, in regards to Mr. Wheeler, 6 prior arrests, 1 FTA in 2014. He may still be under drug court, behavior court for a cruelty in the first 2 counts and aggravated battery.
5 North, stop, turn around, booth 3, 5 North. I'm the most important person right now, not whatever's going on out there. Go ahead, finish up, Bosick, sorry.
That was it.
All right, go ahead, counsel.
Hey, Judge. Yes, Judge. As you heard earlier, he's been in custody for 383 days now without an indictment. As we stated at our previous hearings, Mr. Wheeler is an Atlanta resident. lived here his whole life, lives in the Atlanta currently. His wife is here in court with us, as are his two sisters and mother, and I think his grandmother might be in the waiting room trying to get in. And he has pretty much all his family here and extensive family support here. He's supporting his dependents, including his child with Ms. Sabir and his other children. Were at the time of his arrest, and he was employed at UPS and on track for promotion there when this all happened. Judge, you know, as I was saying, he's been in jail for 383 days. There's been no indictment. You know, obviously, we're not entitled to discovery or any other evidence in this case. He does have a bond granted of, I believe, $175,000, but unfortunately, it's just not a bond that he can make given that amount. And we would ask for a signature bond today, given the length of his incarceration and the fact that he does not have the resources to make any significant bond.
All right. As my understanding, I remember this one. This was an alleged shaken baby case. Miss Amjadi, go ahead. Do we have any updates on the child?
Your Honor, if the court will give me just one moment to check on the child's status.
You don't know Mr. Melnick yet, right?
And the mom is here, Judge, and could testify to that if you'd like her to.
Okay, we got you. All right.
Mr. Malnick is on.
All right, I see. We'll take the other two at ACDC after this one. Go ahead, Miss Amjadi.
Your Honor, according to the notes, the victim is in favor of a bond for the defendant. She does not feel in danger.
This was a shaken baby.
Yes, I think this may have been the parent of the baby, Your Honor.
That's Ms. Sabir, Judge. She spoke with the prosecutor a short while ago, and she's here in court.
Okay, so but how is the child, the shaken child?
Your
Judge,
Honor,
if I can answer, the child, since very early on, has fully recovered, is doing well, and has had no further problems.
What's the status with the juvenile case?
I believe, Judge, that's been closed out at this point. I think there was a safety plan, but that safety plan did allow Mr. Wheeler to be in the presence of the child. But I think at this point, it's been effectively closed out.
And also he has a hold also. Is this the same case? Because this is the 20 SC 176910. There's aggravated battery at 2 counts of cruelty to children in the first degree. It's a probation warrant that was issued April 1st of 2022. Just for your edification. I don't know if you handled it or not, but it's still showing up on the jail screen. Ms. Amjadi.
Your Honor.
Anything else or anything? Go ahead.
Your Honor, with respect to the issue of bond, the state's position is that bond is previously set as fair and reasonable.
And Judge, they've had over a year to do something on this case, and letting Mr. Wheeler languish in jail, I don't think is accomplishing anything.
I usually put on here that they can comply with any juvenile court thing, so I don't even see where they went through juvenile court. But no further contact with ASYA Wheeler. Ankle monitor paid for by the county. If you're picked up on the hold and you go for that probation violation, sir, you'll have 48 hours to have that ankle monitor placed back on your ankle. You'll have a 24-hour curfew except for court appearances, medical appointments, or any emergencies and attorney visits. Work only if your employer is scheduled. The name of your employer, proof of employment is given to your attorney, who will then give it to the state, and a schedule. You also stay away from 316 Skipper Place Northwest Apartment C in Atlanta.
Judge, if I can address that, Ms. Sabir and the child have moved from Skipper Place, so no one is there that's connected to this case. And if Mr. Wheeler were released, that would probably be the best residence for him to stay at. But right now, no one is there currently, the mom or the child.
So, is somebody paying rent there?
I'm not sure. I believe it was another family member's house, Judge. I can ask Ms. Sabir that and get clarification.
Yes, I am still.
Whoa.
I'm sorry.
Raise your right hand, ma'am. Raise your right hand. You swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth.
Yes.
All right, state your name, please, for the record for Madam Court Reporter. You can place your hand down. Go ahead.
Dominique Sabir.
All right, go ahead, counsel. What do you want to ask her?
Ms. Sabir, the Skipper Place residents, are you or your daughter Isaiah still living there?
No, we are not.
Who is there right now?
Right now, no one.
And are you paying rent for that property?
Yes, I am.
Why are you continuing to pay rent for that?
Because my things are there.
But do you have any intention of residing there or staying there while this case is ongoing and the bond is in place?
No.
So then, without giving up the address, where are you living if your things are there? I'm not really following that train of thought.
I'm living with my grandmother, my grandparents.
Was that
They're
required?
my adopted mother and father. No, I just need help with my child.
All right, so if I put, he can go back, he's got to stay away from you. He can't go back to that address if you're going to be there. How long do you plan on
Oh,
living? with
I
your
won't. I won't be there. I live with my grandparents.
Okay. All right. You can only go back to 316 Skipper Place, Northwest Apartment C if Miss Sabir, S-A-B-I-R, isn't there. Ms. Amjadi, so we don't have an update on how the actual infant child, the shaken
Don't have
baby.
any notes in our system, Your Honor.
All right. What's your opinion on it? It's 175,000. I can't believe it hasn't been indicted. It has been 383 days. I'm assuming Mr. Royals will get on this one.
Your Honor, I believe that bond as previously said is fair and reasonable given the totality of the circumstances.
And to reiterate, the state has not taken any action on any investigation or done anything on this case in close to a year. And it's just a file on somebody's desk where nothing's happening. And I think a signature bond is appropriate at this time.
No, that's not gonna happen. But I'll do $125,000. And if they haven't indicted, put it back on, file another motion to modify. If they hadn't indicted, we'll get Mr. Royals here and ask him why it's gonna be, this is over a year because it's 383 days. All right. So we'll see if they can't have some movement. And if you can, counsel, get something from like medical to show what's the medical status of the child, if you don't mind, and maybe send it to Miss Amjadi so we'll be a little more informed next time.
But I've sent that to the prosecutor several times showing the child is fine. It just seems to go into a black hole. And I
You
don't
can shoot
think-
it. You can shoot it to me. Miss Robinson will place my email in the chat.
Thank you.
And you can send it to me. But Miss Amjadi goes back and forth on which one she's going to be working, so don't blame it on her.
Okay.
Too much. All right, thank you. All right, let's see, Mr. Melnick. Let's take care of the rest of ACDCs now. What we call the City of Atlanta. Where are they at? ACDC. Where's City of Atlanta?
Your Honor, real quick, you said 125 for position 11.
Uh-huh.
Okay, thank you.
Where'd City of Atlanta go? Oh, there they are. All right, about Chantel Daniels.
Yes, sir.
All right, it's position 22 CP 212918 Chantel Daniels, 98 days without indictment, no bond as of October the 5th, 2 counts of aggravated assault. Pre-trial.
In regards to Ms. Daniels, 5 prior arrests, 2010 forgery in the first ID fraud and escape, 2017 sale of cocaine, possession of cocaine. Open case 18 SC 160918, aggravated assault with a deadly weapon, aggravated assault 4 counts, terroristic threats, firearm by cruelty 3 counts. Nothing further.
All right, go ahead, Mr. Melnick.
Thank you, Your Honor. Good evening. So as you heard from pre-trial's recitation, Ms. Daniels does not have any prior felony convictions. I have been in continuous contact with the victim in this case, Your Honor, if you will bear with me. She has told me unequivocally that she did not intend for Ms. Daniels to be arrested on these charges, that she does not fear Ms. Daniels, and that it is her desire for Ms. Daniels to receive a bond, which she is obviously very much entitled to receive at this time. Victim's name is Tijuana Jones. She is available at my call if the court would like to address her. Obviously, I know that you don't put victims and witnesses on the Zoom call ordinarily, but I think that it is it is significant that the victim in this case has not just contacted me once. This is not a domestic case. She has been in continuous contact with me, telling me that she believes that Ms. Daniels is wrongfully in jail and that she has reached out to the DA's office and reached out to me as well in an effort to try to get Ms. Daniels out of custody. She believes that police misread and misinterpreted what she told them at the time of Ms. Daniels' arrest. Ms. Daniels she is a single mother. She has 4 children for who are completely dependent upon her. She is gainfully employed, Your Honor. She will be working upon her release from custody. She does warehouse work and she also does home cleaning services. And Your Honor, while I recognize that she does have this 2018 case of a similar nature, that is a 2018 case that as yet has not resulted in a conviction. And Ms. Daniels has adamantly stated that she is not guilty on that offense. So, Your Honor, what I'm asking you to do in this case, if you would like to address Ms. Jones, I can get her on this call. If not, I'm asking you to set a total bond in the amount of $25,000.
So it looks like there were 2 people, Quandarius Green and Tijuana Jones, that allegedly she pointed a gun at.
Right.
Oh,
Quandarius
so-
Green is currently in custody.
Okay.
On something completely unrelated.
It looks like, I don't know if bond said in the 18 SC case, but there was a bond surrender October the 7th.
I'd noticed it, Judge. Probably from the bonding company. She may have to repost her bond on the 2018 case. She and I looking over my notes today. This is I literally just got done with a plea in Cobb County and ran over here to try to get this done. But in any event, Your Honor, so Mr. Green is in custody. That's why I have not spoken with him. But Ms. Jones has told me, and Ms. Jones and Mr. Green are boyfriend and girlfriend. So
Where will she live? Where will your client live?
Ms. Daniels, are you going to be down in Union City? Is that right?
Union City, what was that?
Where's your address going to be?
Oh, 875 Conley Road.
Okay.
All right.
And that's in Atlanta, right?
Yes.
Okay.
It's on Johnny.
This is actually going to be handled by me. Good evening, Mr. Melnick. How are you?
Good. How are you?
I'm good. Judge, we would ask if Mr. Melnick has Ms. Jones available, that she be made available so that she can state her preferences on bond. I think that would inform the court's decision making.
Okay. Yeah, if you want to
on the
contact,
Zoom call, or do you just want to speak with
Yeah.
her, Mr. White now?
she can get on the Zoom call.
Okay.
I think
Bear
he,
with
I
me
think he
for a
wants
second.
it on, we both want it on the record.
Okay. I gotta just call her real quick and get the information.
Let's see if we have one. Miss Rhonda, while he's trying to do that, do we have Alan Woods? Wave your hand. All right, we'll go ahead and handle position 16 and come back to you folks. 22 CP 212066, Alan Woods. 129 days in custody without indictment, aggravated assault, possession of a knife or a firearm during the commission of a felony, fleeing and attempting to elude a peace officer, and pimping. No bond as of September the 5th. Pre-trial.
In regards to Mr. Woods, he has 7 prior arrests. He has an open case in DeKalb for armed robbery, aggravated assault, more serious charge associated with pimping in DeKalb. The other open case at the time of his arrest was no build. Nothing further.
All right. Go ahead, Miss Rondon.
Miss Giovanna Smith from my office will be handling this one.
Okay.
How you doing, Your Honor?
How are you doing? Go ahead.
So before you, we have Mr. Alan Woods. He's 29 years old. He is from Atlanta, Georgia. He lives with his parents at the address that is on the pretrial report. It is 2224 Medora Place in Decatur, Georgia. Before the incident, he was a full-time student. He was attending Savannah State, where he was pursuing his business management degree. So in this case, I do understand that Mr. Woods does have 2 open cases that are a little more serious. However, with the case before us,
Mr. Woods, he is the victim in this case where he was the one that was actually being shot at, which resulted in 3 bullet wounds, 1 in the hand, arm, and back. And Mr. Woods has strongly indicated that for the misdemeanor for fleeing or attempted to elude a police officer, he was trying to get to the hospital as quick as possible due to his injuries. So in this case, due to Mr. Woods being in holding without bond for 129 days, meaning that he is entitled to bond, we are requesting that Mr. Woods receive a reasonable bond at $12,000, $5,000 for both of the felony offenses, and $500 for the fleeing or attempting to elude a police officer misdemeanor, as well as $1,500 for the misdemeanor of pimping. And we consent to a stay away order from the incident location at the Comfort Inn Suites at 5793 Roswell Road in Sandy Springs.
All right. What is this one? Ms. Amjadi.
Thank you, Your Honor. The defendant poses a risk of reoffending. He has 8 arrest cycles since 2010 when he was 17 years old. Additionally, we do have a lot of community safety concerns given the nature of these offenses here. For that reason, Your Honor, the state, while acknowledging that the defendant is entitled to a bond at this time, would respectfully request that any bond the court grants be no lower than $50,000 for the count of aggravated assault, no lower than $25,000 for possession of a firearm, $50,000 for the charge of fleeing, and $15,000 for the misdemeanor pimping, Your Honor.
Right. So I've read this and it does say that detectives, let's see, where'd it go? Just lost it. His initial discharge of his firearm may have been justified. However, when he drove in his car to Carpenter Drive, Roswell Road, and stopped, took a defensive position, began firing his rifle at the 3 men who were no longer a danger, he committed the offense of aggravated assault. So he shot at people with a rifle. No drugs unless prescribed, no alcohol, no weapons, no further contact with Giovanni, Giovanni, Vicente, Vincente. Stay away from 5793 Roswell Road in Sandy Springs. No further contact with the minor. Her initials are AJ. AJ. You have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, and medical. Stay out of Fulton County, sir. You live in Decatur. Stay out of Fulton County. The only reason you come to Fulton County is see your lawyer or come to court. Get gas in DeKalb County, drive to Fulton County, go to court, then go back home. Don't run out of gas, get a flat tire, stop and get anything to eat or any other thing in Fulton County. If you get on 285, make sure you don't run out of gas there, sir. Have we heard from how the victim is in this one?
Let me check, Your Honor. To request an investigator to find updated victim contact information.
All right. All right, so we got 30,000, 10,000, 20,000, 15,000, 30, 10, 20, and 15. Best of luck to you, sir. All right, Mr. Melnick, do you have your alleged victim on the phone on Zoom yet?
Your Honor,
I've
may I
sent her the
interject?
link. I'm sorry, ma'am.
Yes, ma'am.
I'm sorry, may I interject? Since that was my last case, may I be excused?
Yes, ma'am. Enjoy your evening.
All right, thank you, Your Honor.
All right.
It doesn't
Judge,
look
can I
like
get
she's
some
on yet.
insight on this, Daniels?
Oh, well, that Mr. Melnick was trying to get in touch with Ms. Jones.
No, on the open case, Judge, that was a pretrial bench warrant. She's been on pretrial since 2018. The bond surrender was done due to the fact that she has the new case. She had been compliant for 3 years until this new case.
But that one was, that bond still surrendered, so she'll have to address that
Yes,
one again.
it's for $32,000, the judge cost case.
Okay. Mr. Melnick, no, not able to get contact with Ms. Jones?
No, I've contacted her. She just hasn't gotten on the call yet, Judge. I literally just got off the phone with her.
All right, let's take care. Okay, Ms. Daniels, if you can scoot to the side, we'll take care of position 3, Kalina, Texas. That's a town, isn't it? 22 CP 212946, Kalina, Texas, 97 days without indictment, aggravated assault, reckless conduct, discharge of firearms near a public street or highway. No bond as of October the 6th. Pre-trial.
Judge, Miss Kalina, Texas has gotten about 2 arrests in Minnesota, 2 in Illinois, and 3 in Georgia, but minimal conviction. 14 obstruction and an 05 assault with a deadly weapon. Nothing further.
All right, go ahead, Mr. Melnick.
I'm sorry, what was that last thing that she said, Madam Pretrial Officer?
Last thing about what?
Something
14
about,
obstruction or 05 assault with a deadly weapon.
okay, you said that was a conviction?
Yes, they are.
Okay. All right, well, in any event, Judge, Miss Texas is 38 years of age. She lives on First Street in Atlanta. She has 5 children who are dependent upon her, ages 19, 17, 16, 12, and 11. She is self-employed, Judge. She has a tax service company called Miss Texas Tax Services, and she also does security for entertainers with a company called T4 Enterprises. Your Honor, so you can see from the warrants in this case, Miss Texas was not initially arrested on these charges. She spoke with the police, told them what happened, provided information to them, provided evidence to them. What appears to have happened is that Miss Texas was surrounded by some people in her vehicle. There is an allegation that Miss Texas shot from the vehicle. It is my understanding that there was actually another party inside of Miss Texas's vehicle that was the one doing the shooting, but it's also clear, and you can see this from the warrants, Judge, that Miss Texas's vehicle was also shot at. And Miss Texas was able to show that to the officer that was investigating this case. And there is also physical evidence where there were bullet holes in Miss Texas's vehicle. She has a minimal criminal history, Your Honor. All of her children live here with her, and she has very strong ties to the community. She has demonstrated that she is not a flight risk by virtue of her cooperation with authorities in speaking with them in this case. Prior to her arrest, they came to speak with her on more than one occasion. And when they arrested her, she was at her home, knowing that there was an investigation surrounding this incident. Ms. Texas also called the police the night of the incident to report what had happened to her. So, Your Honor, what I'm asking you to do in this case is grant her a minimal bond in the amount of $20,000.
Ms. Amjadi?
Your Honor, given the offenses alleged here and the public safety danger and the danger that the defendant poses to the victims, I would respectfully request that the bond for the aggravated assault charge be no lower than $80,000, that the discharge of firearms on or near a public highway or street be no lower than $10,000, and the reckless conduct be no lower than $5,000.
Do we have any information about the Miss Gooden? The victim was actually shot.
I will check, Your Honor. We did not at the time that I was preparing this particular position this afternoon, but let me see if we have anything since then.
All right. We'll start with no drugs unless prescribed, no alcohol, no weapons, no further contact with Angela Gant. Let me spell this name. It's ADBULWALI, last name Mohammed, and then first name MAKIEL, last name Mohammed, and no further contact with Kamiya, KAMIYA, last name Gooden, GOODEN. Stay away from 901 Parsons Street. And where's she gonna live, Mr. Melnick?
It's
At First Street in Atlanta.
241st Street in Atlanta, Judge.
All right. Should have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, and she already has a job.
She does, Judge.
Okay, employment, just gotta get proof of employment schedule, the location you'll be working, turn it over to Mr. Meldick, ma'am, and he will turn it over to the state. You find out anything, Miss Amjadi?
Nothing, Your Honor. I apologize. I will make sure that somebody calls and makes contact this week.
Okay, you got 20,000, 5,000, and 5,000. 20,000, 5,000, and 5,000. And ma'am, I think if there's any holds or anything that pops up, you have 48 hours to have it placed on your ankle, but I don't think you have anything. Best of luck to you, ma'am. Still nothing for Miss Jones.
So, Judge, I've sent it to her again. Hopefully she got it. If you will let me just pause for just a moment. I'm going to call her, just make sure she's not having some kind of technical issue.
All right, we'll go Jamal Thomas. Wave your hand. All right, 22 CP 207-674 Jamal Freeman Thomas, 294 days without indictment, aggravated assault, strangulation, criminal trespass, $7,500 good bond as of March the 24th. Pre-trial.
Judge, in regards to Mr. Thomas, open case 22 SC 183,000, obstruction, 2 counts, felony firearm by theft by receiving stolen property assigned to Judge Eden. 2 arrests in Georgia, 7 in Texas, 18 in Louisiana. In Louisiana, he has an unlawful to possess a scheduled substance. And then in Texas, he has a 2016 assault bodily injury and 4 misdemeanor convictions. Nothing further.
Go ahead, Ms. Rondon.
All right, before you is Mr. Thomas. He is 38 years old and has been in Atlanta for the past 5 years. He will have a new address. That is 262 Sunset Avenue in Atlanta. His cousin lives there and he would be able to live with his cousin. He does have his GED. He has 3 kids. They are 12, 14, and 9. Prior to his arrest, he was working at demolition work, which does housing demolition. And it is my understanding that he could get his job back upon being released. We would consent to an ankle monitor and a curfew with exceptions for work, court, and medical. We would please ask the court to reduce the bond as it is set, as Mr. Thomas is indigent and cannot afford the bond where it is now.
All right. Ms. Amjadi.
Judge, that's actually going to be mine. Your Honor, we'd ask that bond be maintained as is, given the defendant's extensive arrests and convictions out of various states. I think that given the facts in this case, the defendant punching and choking the victim, in light of that criminal history, 17.5 good bond is a reasonable bond, and we ask that it be maintained.
All right, let's see. No drugs unless prescribed, no alcohol, no weapons. Stay away from 1031 Fair Street Northwest. No further contact with Cherry, CHERRY Dunlap, DUNLAP. No further contact with Jamal Freeman Thomas. I mean, excuse me, that's your name. All right. No, I guess there's a junior, isn't there?
Judge, my understanding is that the victim is Cherry Dunlap, as you mentioned.
Yeah, okay. I didn't know if there was a junior here. All right, you're gonna have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical. Is he gonna work, Miss Rondon?
Yes, we would ask for an exception for work, please.
All right, employment, as long as he supplies proof of employment, the name of his employer, a schedule, and the location he'll be working. Sir, you have to do that every single time. And if you're not gonna live at 2626 Sunset Avenue, you have to provide an address where you'll be living, not where you're getting your mail, where you'll be living. 12,000 and 2,000, 12,000 and 2,000. Best of luck to you, sir. No,
Thank you,
Miss
Judge.
Jones. All right, Jared Adams. Rhonda, you gonna handle this one too?
Yes.
All right, 22 CP 211207 is position 15. Bostic. Jared Adams, 158 days with no indictment. Aggravated battery, forgery in the first degree, forgery in the first degree, forgery in the first degree, possession of a knife or a firearm during the commission of certain felonies, and 2 counts of willful obstruction. Pre-trial. Jared Adams, 15.
I got it. Unauthorized discharge, disorderly conduct, on probation in Bartos, sentenced 2/16/2022, 1 year confinement. No, conviction on unauthorized discharge and disorderly conduct, on probation for criminal damage to property in Bartos, sentenced 2/16/2022 in Bartos. 1 year confinement, 9 years probation. Nothing further.
Go ahead, Ms. Rodman.
All right, before you is Mr. Adams. He is 24 years old. He's born and raised in Atlanta and has his whole family here. He has one daughter that is 1 year old. He is working on his GED. Before his arrest, he was working at Atlanta Hartsfield Jackson at the Enterprise rental car. It is my understanding he could get his job back. He has done a lot of good work while he has been in custody. He has successfully completed several classes, including life skills, substance abuse, and a Thinking for a Change course. We also, I understand this is not a probable cause hearing, but we do have issues with how the incident is presented within the warrant. So we would be asking this court to please set a reasonable bond in this case, not to exceed $25,000.
I lost you, Ms. Rhonda. Sorry, go ahead. He's working on his GED.
Oh no, we missed all of that.
Sorry, I don't know. You know.
Okay. So he's working on his GED. Before his arrest, he was working at Hartsfield Jackson at the Enterprise rental car, and it is my understanding that he could get his job back. He has done some great work while he has been in custody. He has successfully completed several classes, including Thinking for a Change, substance abuse, and life skills. I know this is not a probable cause hearing, but we do take issue with the way that the warrant represents the events of the incident. We will be challenging that at his preliminary hearing. With that in mind, we are asking this court respectfully to please set a reasonable bond in this case, not to exceed $25,000.
All right. What says the state? What says the state?
20,000 figure is a bit low. I do understand that the defendant is now legally entitled to a bond. And I also applaud the steps that he's taken while in custody. However, these are very serious violent offenses that have resulted in injury to the victim. So the state respectfully requests that any bond the court chooses to give be no lower than $20,000 for each count of aggravated battery. I have no objection to a $5,000 bond for each of the forgery counts. But for the firearm charge, I would respectfully request a $25,000 bond and $5,000 for each of the obstruction charges as well, Your Honor.
All right. No drugs unless prescribed, no alcohol, no weapons, no further contact with Alton Starr, S-T-A-R-R. He's going to live in Morrow, Georgia, right, Miss Rhonda?
No, the address that we're going to have him live at is in Atlanta.
Okay.
And I'll get that address changed.
Okay, stay away from 2905 East Point Street. No further contact with K-I-A-E-R-R-A, last name C-A-N-A-D-Y. Gonna have an ankle monitor paid for by the county with a 24-hour curfew except for court, lawyer, medical. So I'll do 20, 5, 5, 5, 25, 5, and 5. 20 on each aggravated battery, 5 on each forgery, 25 on the firearm, and 5 on each obstruction. Best of luck to you, sir.
Your Honor, could we include an exception for work?
Okay, yep, all right, work as long as he provides name of his employer, proof of employment schedule, and the exact location he'll be working. He has to supply that to you and you'll supply that to the state. Any like Mr. Melnick?
Yes, Your Honor, she's on.
All right, where is she at? Miss Jones?
Miss Daniel.
Miss Daniel, sorry. Miss Daniel?
Miss Daniels, turn your screen on and your.
No, Miss Jones.
Miss Jones is the victim.
I am so sorry. Everybody's
All right.
right. I've had a long day, y'all.
Here I go. Here I go. I'm up on my baby.
Okay, hold on. Raise your right hand, ma'am. All right, you swear affirm testimony you're about to give is the truth, whole truth, nothing but the truth.
Yes, ma'am.
All right, go ahead, Mr. Wittenhauer. I'm sure you have some questions.
You can lower your.
Yes, ma'am. Ma'am, I understand that on or about October 4th of 2022, there was an argument with Miss Daniels. Is that accurate?
You talk to me, sir?
I am.
Put your hand down. You can put your hand down.
Yes, we had got into a slightly argument.
Okay. And during that argument, did Miss Daniels have a firearm?
Yes, she did.
Okay.
But I was so angry. It wasn't never pointed at me.
Okay. And did she ever take that firearm out of her waist or wherever she had it?
I guess she saw me before I saw the verbal argument that we got into. We apologized with each other that day, but by my boyfriend getting into it with her too, I guess she was scared. But I didn't see her come in the store, so I guess she said,
Miss Jones, listen to his question. Focus for me. Go ahead and ask the question one more time.
Yes, Judge. Thank you, ma'am. You indicated a moment ago that Miss Daniels did in fact have a firearm. My next question was, did you see her pull that firearm out of her waistband or her purse?
No, I didn't see her pull it out her waistband or no purse. I didn't see no purse or nothing.
Okay, where did she have it when you saw it?
It was in her hand. I never saw it in no purse.
Okay, and when she had it in her hand, did she point it in your general direction or in the general direction of Quandarius Green?
No.
Okay, and how do you know Miss Daniels?
She was a neighbor. She was a neighbor to me, and when I was going through my little situation, she took me to the store a couple times to get groceries.
Okay, nothing further from the state. Thank you, ma'am.
All right. Anything you want to go ahead on your numbers, Mr. Wittenhauer? Sorry.
Yes, Judge. I would just note, and Mr. Melnick is correct that in the 18 SC case, it is a pending case. However, in that case, the state has alleged that Miss Daniels was in possession of a firearm and did point it at another individual in traffic. And that vehicle had an adult as well as some minor children. So again, here we have Miss Daniels with the firearm and allegedly pointing a firearm at two individuals. So we would ask that at a minimum, your honor set bond on each aggravated assault in the amount of $10,000 good, that there be no contact with either victim, a stay away order for 807 Connolly Road, that she not possess any firearms and that she be subject to, that she consume no drugs or alcohol and be subject to screens. Nothing further from the state.
So you said 10 on each count?
Yes, Judge.
Okay, well, 10 on each count of aggravated assault, no drugs unless prescribed, no alcohol, no weapons, no further contact with Tijuana Jones, no further contact with Quandarius, Quandrius Green. Stay away from 807 Conley Road in Atlanta, Georgia. Going to have an ankle monitor supplied by the county with a 24-hour curfew. Court, lawyer, medical. Mr. Melnick, she want to get a job?
Yeah, she is.
Okay, and employment. You got to give the name of your employer, proof of employment, a schedule, and the exact location you'll be working to Mr. Melnick. And in that case, then he will turn it over to the state. So $20,000 total good bond. Best of luck to you, ma'am.
Thank you, Judge.
Thank you. Let's see, DeQuanta Hunter. All right. Ms. Ronan, so we got position 19, Bostic 22 CP 210375, DeQuanta Hunter. 824 days without indictment, but there's another case he's there for, so he has been indicted. That's a 21 SC 179772. This has happened recently. This count of aggravated battery and aggravated assault with a deadly weapon. No bond on these two charges as of July the 5th, but he's been in there because of the other case has been indicted. Pre-trial.
Judge, 10 prior arrests. Conviction, purchase, manufacture, sale of marijuana in 2016. The open case is ag battery, 2 counts, aggravated assault with deadly weapon, firearm during criminal attempted armed robbery, firearm by a convicted felon. Nothing further.
All right. Go ahead, Ms. Rhonda.
All right. Before you is Mr. Hunter. He is 24 years old and a lifelong resident of Atlanta. He does have a good address on file. That is where he can live with his mother. His mother has lived at that address since 2006. He has completed the 8th grade and does have a 4-year-old son. He was working at the Sports Bar and Grill, and it is my understanding that he could get his job back once he is released. We would consent to an ankle monitor and a curfew with exceptions for work. And we would please respectfully ask this court to set bond in this case as he is entitled to it, and we would ask for no higher than $30,000.
All right, what says the state?
Your Honor, if I could have just one moment.
Sure. And Ms. Rhonda, for some reason on here, there's a robbery and a criminal trespass outstanding warrant that's listed on the Odyssey. Do you want those EW numbers?
Yes, please.
All right, EW 0130 132 and 133.
Okay.
Of the offense, I think that 30,000 is a bit too young, a bit too low a number. I would respectfully request that the court grant a bond no lower than $20,000 per count, given that the victim in this case was stabbed.
You said 20,000 per count?
Yes, please, Your Honor. No lower than 20,000 per count.
All right. No drugs unless prescribed, no alcohol, no weapons. No further contact with Maurice Lawson, Lawson. No further contact with Vernon Young. You have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, and medical, but you got no bond in the 21 SC case, so you won't be going out. Address he'll be living, Ms. Rhonda?
It is the address on file, 3136 Martin Luther King Drive.
Okay. That ankle monitor be placed on you within 48 hours if there's some sort of hold. 20,000 on each count, a total of $40,000 good bond. Best of luck to you, sir. And to whomever place it, Mohammed Lawimba. The reason we're skipping position 4 is Lieutenant McDaniel decides the rotation, and we go by what he says, not what I say, by what Lieutenant McDaniel says. You can stay on mute, sir. I'm going to keep going. All right. Let's see. I got DeMorris Nichols. DeMorris Nichols.
Judge, that is my other case, but ironically, the phone with him and he was asking me why he wasn't brought up for court yet. So he is in 5 South, I think 5 South 400. So I'm ready to go on his case whenever he's brought up.
Put him in there. All right, let's see. All right, Demetrius McDowell. I think I see Kayla Bumpus. Where's it? Where's Kayla? Where's it?
I'm on here, Judge, but can you come back to me?
Okay.
I'm having an issue with my child.
Okay.
Just
All
give me
right.
15 minutes, Judge. I'm sorry.
That's okay. Barry Nelson. Mr. Nelson. Mr. Nelson, wave your hand. Okay, so sir, you go out and let Mr. Nelson sit in here. All right, Barry Nelson, 22 CP 212126. 124 days with no indictment, aggravated battery, aggravated assault, no bond as of September the 8th. It's position 17. Pre-trial.
Judge, Mr. Nelson, extensive arrest history, 44 prior arrests, couple of FTAs, 2019, 2020, couple of felonies in the 90s, 2021 Schedule 1 substance, still on probation, Hall County, 3/2/21, sentence 30 days confinement, 2 years, 11 months probation, 13 misdemeanor convictions, nothing further.
Go ahead, Ms. Rhonda.
All right, this is Mr. Nelson. He is 60 years old and a lifelong resident of Atlanta. He does have a brother that lives here, as well as his niece where he can go live. And that address would be 6711 Hill Rock Lane in Fairburn. I will submit a change of address for him soon. He does have 2 children who are grown adults. We do contest the allegations in the warrant and look forward to that at a probable cause hearing. We would respectfully ask the court to please set reasonable bond in this case, not to exceed 20,000.
So the uncle he plans on living with isn't Craig Nelson, is it?
It is not, no.
Okay, all right. What says the state?
Your Honor, I believe Mr. Craig Nelson is here before the court today.
All right, let's see, Mr. Craig Nelson. I don't see him. Maybe he left.
He may have. Ms. Ferreira, did you get to speak with Mr. Nelson?
Hi, can you hear me okay?
Yes, thank you.
Mr. Nelson, can you tell me his position? Because I took the notes that way.
17.
Position 17.
Okay. One moment. Because of, Odyssey, I'm going through in and out, but let me see what I wrote in my personal notes. 17. Yes, and he was against bonds.
Okay.
Okay.
I just have 17 no to bonds, but I have more in Odyssey if you could get in.
Thank you. I
You're-
appreciate that.
No worries. I mean, he should tell me his name again. I could text him.
It was Craig Nelson, and your note indicated you spoke to the niece who was the caretaker.
Oh, okay. I know exactly what this is. So she's pretty much not just the caretaker, but I guess she's been awarded like the person making all decisions for him. He's actually still hospitalized and he's like in bad shape. Like he can't even speak on his behalf. So that's why she was like, absolutely. And apparently she's the niece. And I recall that she said that that's the brother, and that even though he has mental health issues, she felt that the defendant, the brother, beat the victim to near death.
Okay.
Those were her words. So I couldn't speak directly to him because he's hospitalized.
All right. Go ahead, Ms. Amjadi.
Your Honor, given the severity of the offense and the extensive criminal history of our defendant, I understand that the defendant is legally entitled to a bond at this point, but I think it would only be fair and reasonable to ask that any bond given be no lower than $100,000 per count.
No drugs unless prescribed, no alcohol, no weapons, no further contact with Craig Nelson. Stay away from 583 Haynes, Paines Avenue Northwest in Atlanta. No further contact with DIA Nelson, NELSON. I think there was a Big Philly. No further contact with Big Philly. I don't think that's his real name. However, no further contact with Big Philly. Ankle monitor paid for by the county with a 24-hour curfew except for court, lawyer, and medical. $100,000 on each count, $200,000 good bond. Best of luck to you, sir. You can leave the booth.
I'm ready now, Judge, if you're ready for me.
What do you do with those children?
They're quiet. You two kids.
All right. Demetrius McDowell. Mr. McDowell. All right. It's position 12, Bostic 22, CP 212798. Demetrius McDowell, 103 days with no bond. Aggravated assault with a deadly weapon, possession of a firearm during the commission of a felony. No bond as of September 30th.
Judge, 9 prior arrests. A simple battery in 2014 appears to still be on first offender probation for aggravated assault, 2 counts firearm during sentence 8/9/19, 1 year confinement, 5 years probation, 18 SC 159734. Nothing further.
All right, go ahead, Ms. Bumpus.
Yes, Your Honor. My client is an Atlanta native. He has family support. I believe his mom, dad, and aunt are on the call right now. And I'm sorry, grandma. His grandma is Miss McDowell. You see her. She has the beautiful smile right there.
Yes,
That
ma'am.
is who he would be able to go and reside with. Prior to this incident, he was gainfully employed. I'm not sure if that job still remains, as he has been in custody for over 90 days. But like I said, he does have family support. He has one son, and I do believe he'll be able to get a job rather soon if he is granted a reasonable bond. Like as you heard Ms. Bostic say, he's on first offender probation. However, that case is from 2018 and it's 2022. He hasn't been in any trouble since then. So I would just ask the court to grant a reasonable bond. I do know that this is a bond hearing. So there are specific factors that you like to hear, but briefly, I would like to say that I don't believe that there are any eyewitnesses or any evidence that's put my client as the shooter or the one that had a gun or anything. I would just ask the court to consider all of that and grant him a bond. And I would ask that bond be under $30,000 total.
All right. What do you know the address he'll be living in Atlanta?
Ms. McDowell, could you state that address? You gotta unmute it. Unmute your phone. I have that. Push unmute.
It's 249 Winwood Drive, Atlanta, Georgia, 30310.
Thank you, ma'am. What says the state? Ms. Andrade, go ahead.
Oh, thank you, Your Honor. I'm sorry, the sound cut out for a moment.
And I understand, Ms. Bubba, that this incident date was actually October 24th, 2020, and he was just arrested in September 2022.
Your Honor, given the nature of the offenses, the state's position is that any bond, understanding that he is legally entitled to a bond at this time, the defendant, we would ask that any court grants the defendant be no lower than $25,000 per count.
All right, no drugs unless prescribed, no alcohol, no weapons.
Your Honor, may I just say something briefly?
Okay.
Your Honor, anything over 40,000 will leave my client in a no bond status. He doesn't have the resources. So I would just ask, instead of giving him a significantly high bond because he won't be able to afford it, to, I guess, in lieu of that, put him on an ankle monitor or something like that.
All right. No drugs unless prescribed, no alcohol, no weapons. No further contact with Jakar Williams. Stay away from 243 Florida Avenue. You have a 24-hour curfew. Ankle monitor paid for by the county, except for court, lawyer, medical, and work. This happened in 2020. Work. You have to supply the name of your employer, proof of employment, and a schedule and the exact location that you're going to be working, sir. You have to give that to your lawyer, who will in turn give that to the state. So I need 15 on count one, 15 on count two. Best of luck to you, sir.
Thank you so much, Judge. And that concludes my business. May I be excused?
All right. Thank you, Ms. Bubbles. Have a good evening.
Okay.
All right. Kevin Washington. Kevin Washington. No Kevin Washington? What about Martez Dukes? Mr. Dukes. Martez Dukes. What about Alfred Dodd?
I apologize, Your Honor. I'm here for Marquez Dukes. Did he not?
No, nobody's waving their hand. The only one that raised their hand was Alfred Dodd.
All right.
I'm here for Alfred Dodd. I'm here for Alfred Dodd, Judge.
All right, because some of these folks, who are these other people? Because I ain't got but a couple more people. Corey Rhodes. Wait, why 3 people? Everybody, Corey Rhodes. Okay, the other person. Who is Kevin Washington? Martez Dukes. And then we got DeMaurice Nichols. some folks in here just watching television or something, I think. All right, Alfred Dodd. We got 22 CP 211486, 149 days without indictment. Right now there's a $10,200 good split bond because there's no bond status on counts 1 through 10. And 11 has $5,000 good bond. And 12 has a $5,000 good bond. We got Alfred Dodd, theft by receiving stolen property, possession of firearm by a convicted felon, possession of firearm by a convicted felon, and possession of firearm by a convicted felon. We got possession of a firearm during the commission of or attempt to commit certain felonies ×3. Seatbelt violation, adult VGCSA, possession of Schedule 1 or 2, crossing the guard lines of a correctional institution, prohibited items, giving a false name, address, date of birth to law enforcement officer, and theft of lost or mislaid property. Pre-trial.
In regards to Mr. Dodd, extensive arrest history, 34 prior arrests, probation violations, 2 FTAs, 4 open case, 22 CP 212425, aggravated assault, 22 CP 214557 for escape. Prior convictions for tools, cocaine, firearm by a convicted felon, theft by receiving stolen property, and firearm during. Nothing further.
All right. Go ahead, counsel.
Good evening, Judge. I did read the warrant, and we believe that a lot of these charges are problematic. I know a bond.
Counsel for Mr. Dodd.
Yes, can you hear me, Judge? Judge, can you hear me?
She froze.
Can you hear me, Judge?
The judge froze.
Hello?
The judge froze, sir.
Mr. Luumba, can you hear me?
Yeah, I can hear you.
Yeah, the judge's computer apparently froze, and so she's not hearing or seeing what we're saying, presumably. So just stand by.
Oh, okay.
Judge Manning will be back on momentarily. Please just stand by. Thank you.
Sorry, guys, don't know what's going on. All right, sorry about that. Go ahead, counsel for Mr. Dodd.
Yes, good evening, Judge. Can you hear me?
Yes.
Yeah, good evening, Judge. I understand that the bond hearing isn't the time to go over the facts of the case. So we do believe that he was overcharged, and a lot of these charges are problematic. Mr. Dodd is a lifelong resident of the city of Atlanta and the state of Georgia. If you do look at the warrant, even though there are a litany of charges on there, none of these charges are violent. No one was hurt in any of these charges. He is not a flight risk. He will return to court. If when he is released on bond, he's not a threat to any witnesses, nor will he intimidate any witnesses, and he is not a threat to commit any future felonies. He has been incarcerated for 149 days, so he is entitled to a bond, Judge. He does, upon release, plan on getting back to work and trying to continue his education. At this time, Judge, we're asking for a $50,000 bond for all charges.
What says the state?
Your Honor, Mr. Dodd is an APD repeat offender. Additionally, we do have some serious firearm related case charges here. With that in mind, the state would respectfully request that any bond the court grants for these offenses be no lower than $15,000 for the charge of theft by receiving stolen property. That was a vehicular theft, Your Honor. With respect to the firearm by convicted felon charges, we would respectfully request that the bond granted by the court be no lower than $25,000 per count. With respect to the firearm charges during the commission of certain felonies, the state would respectfully request that the court grant a bond no lower than $25,000 per count. The court has already granted a bond for the seatbelt violation. For the VGCSA charge, Your Honor, for Schedule 1 or 2, the state respectfully requests a bond no lower than $10,000, a bond no lower than $10,000 for the crossing guard lines in correctional institutions, $5,000 for the false name, and $5,000 for the theft of lost or mislaid property. For an aggregate total, Your Honor, of $200,200. And no contact with the victims, no possession of weapons or replicas of weapons, and a 24-hour curfew and ankle monitoring, Your Honor. Thank you very much.
Judge, a brief rebuttal.
Okay.
Did you say I could rebut, Judge?
Yeah, go ahead.
Yeah, thank you, Judge. Those numbers are egregious and extremely high. That's tantamount to no bond. He cannot afford that. We understand that though there are a lot of charges, we believe that he was overcharged in this situation. He's been sitting in the jail for 149 days. At this point, what the state is doing is trying to punish him for things that he hasn't been convicted of. Those numbers are extremely punitive and draconian. That's not the purpose of bond. The purpose of bond is to ensure that my client returns to court. He will return to court. We plan on fighting these charges extremely vigorously because we believe that once all the facts come out, most of these charges, if they're all even presented to the grand jury or even brought up in the indictment, most of them will be able to dismiss on motion, John. So to hold him in jail on charges that we believe that as soon as we get the discovery, we'll be able to file some motions to go ahead and neutralize those charges. At this point is just punitive. And I believe Mr. Dodd deserves a $50,000 bond on all charges if you add up all the factors in his case, in addition to the fact that he's been rotting in jail for 149 days.
All right, no drugs unless prescribed, no alcohol, no weapons, no further contact with Greg Bossen, Bossen. What's his address he's going to live at, counsel?
It's going to be in Fulton County, Judge. I can put that in the chat. I don't have it on me, but I can call his girlfriend.
Okay, stay away from 1903 Piedmont Road. Gonna have an ankle monitor paid for by the county with a 24-hour curfew except for court, lawyer, medical attention. No further contact with your co-defendant. Sequoia, Saquoya, last name Nicholson, Nicholson. All right, so I've got 15 on count 1, 10, 10, 10. 10 on each possession of firearm by a convicted felon, 15 on each possession of a knife or a firearm during the commission of a felony. Seatbelt violations, $50. BGCSA Schedule 1 or 2, 10,000. Crossing the guard lines, 5,000. False name, make that 4,000. And mislaid property will make that 4,000. So it's 15, 10, 10, 10, 15, 15, 15, $50, 10,000, 5,000, 4,000, and 4,000.
I got it, Judge.
All right, best of luck to you, sir. You can leave the booth.
Thank you, Your Honor. That concludes my business. May I be excused?
Yeah, thank you too.
Thank you, Judge.
All right, Corey Rhodes.
Okay, excuse me, Your Honor.
Yes, sir.
Before you go to Mr. Rose, Mr. Daniels, Mr. Rodney Daniels, raise your hand. You do not have a case this afternoon, sir. They called for a Daniels, but it was a female from ACDC. You do not have a case today. You can leave the booth.
Thank you,
Thank you,
MT.
sir.
Thank you, Ms. Herrick. Thank you for being so patient. All right, it's Corey Rhodes, 21CP204369. Right, 1,055 days without indictment. However, he has been indicted on another case, so he hasn't been there 1,055 days on this. He's been indicted on another case that's holding. So he has been indicted on the other case. This is an aggravated assault with a deadly weapon. As of 11/8/2021, there is no bond. Pre-trial.
Corey Rhodes, judge, a lot. 21 prior arrests, 2 FTAs, 2011, 2019. Judge Eaton case, 20 SC 177025, street gang, aggravated assault, 9 counts. That's 11/23/19 offense date, 21 CP 198655. Attempt a conspiracy to VGCSA, 21 CP 204451, criminal attempt at a capital offense, street gang, aggravated battery, 4 felony convictions, 1 being a hijacking, parole violations, probation violations, currently on probation for burglary, sentenced in 2011, a 15-year sentence. Nothing further.
All right, go ahead, Mr. Herrick.
Thank you, Judge. Thank you, Judge. This is Corey Rhodes. He's 40 years old, and if released from custody, he'd be living at 2000 Boulder Crest Road, Southeast, Apartment C2. That's in Atlanta, and that's his mother's place. I've been in contact with his mother. She's very active and keeps tabs with me to find out progress and about trying to get him a bond on this case. This case, Judge, by my math, has been around for 428 days. And it was from the 7th of November, 2021. And he would, Judge, for the record, he would agree to stay away from the location. And that would be 901 Rice Street. This was a jail incident. Misunderstandings happened there, Judge. We know that it's overcrowded and there's lots of men there in undesirable conditions. He's an Atlanta native. He was born in Atlanta. He's lived here all his life. His father is Timothy Jackson, works at a Walmart distribution center in Decatur. He's 64. And his mother, Ms. Rhodes, she works Eastlake Harbor Nursing Home. She's been there for 31 years. In Decatur, in the Kirkwood area. He's got 2 brothers, Aaron Rhodes, who's 39, and he's disabled. And we also have DeAnthony Rhodes, 32. He works. He also has a sister, Zandria Williams, and she runs or works at Williams Towing Service in Decatur. He's married. He doesn't have any children of his own. He has 1 stepdaughter who's 11, Trevea Turman, and her mother is Ava Turman. Ava, his wife, she's a store manager for a Bojangles and Hardee's, and she's been managing restaurants for some years, and he's previously worked with her when she was managing Burger King, but I'll get to that more in a second. He didn't graduate from high school, but he did complete his GED, and he also completed 7 trades degrees when he was incarcerated. The highest degree that the highest grade he did complete was 9th grade, so he dropped out in the 10th grade. But again, as I said, he completed that GED in 7 trades: carpentry, barber, bridging, DOT, tree service, landscaping, certified baker. And prior to being arrested, he was using one of those, actually. He was working with DOT and doing some flagging. If he's not able to get that job when he is released, he would be able to work with his wife. He had worked with her in fast food at Burger King when she was managing the Burger King, and that worked out well for them. And he feels like he'd be able to get another job with her. When he was working with her, he was on probation, and he would send his probation officer check stubs and check in and out with his probation officer. Your Honor, he has been in for more than 90 days, so he is entitled to a bond. He does have a few other cases, but I think this is the only case that I have with him that he doesn't have a bond. If the court could set a bond that would be reasonable, and in this case, I think that would be something like $15,000, then he does have other cases, and those other cases do have their own conditions. His primary concern, Your Honor, would be being able to work and being able to contribute to his family. So if there's to be an ankle monitor, which it seems that there is generally, then we'd ask for the work exception. And again, he will stay away from 901 Rice Street.
Go ahead, Ms. Amjadi.
Thank you, Your Honor. As Mr. Herrick indicated, this was a jail incident. The victim was one of the fellow inmates. The court previously denied bond on the basis of the fact that the defendant posed a risk of reoffending. His criminal history shows 22 arrest cycles since 1999. What is noteworthy is that one of these arrests from 2001 was a hijacking. And for that case, he received a sentence of 11 into consideration when assessing the fact that we have 22 arrest cycles since 1999. There are 2 failures to appear, one from 1999, another from 2019. Additionally, we have cases before the court right now, 3 of which are violent, one of which is a violation of the Georgia Controlled Substances Act. There was an attempted gang murder, another gang case involving armed robbery and ag assault. And I appear to have been remiss in making a note of what that 3rd case was. Oh, wait, it was this case, Your Honor. I apologize. With all of that in mind, Your Honor, the defendant does pose, in addition to a risk of reoffending, he poses a danger to the community and persons therein. For that reason, we would respectfully request that the court grant a bond no lower than $150,000 for this charge of aggravated assault with a deadly weapon. Thank you.
All right, because he's got the 20 SC, that's participation in gang activity, and then there's 9 counts of aggravated assault. There's a deadly weapon and a 21 CP. 21 CP 204369. There's an aggravated assault. The possession of a knife or firearm was DWAP. And then there's 21 CP 204451, criminal attempt to commit murder, participation in criminal street gang activity, and aggravated battery. This would be no drugs unless prescribed, no alcohol, no weapons, no further contact with Devin Lynn, no further contact with your co-defendant. All I have is C. Woods. That was all I had. Do you have a first name by any chance, Miss Amjadi?
Corey.
Okay. So it's also Corey Woods?
Yes, ma'am, according to the warrant.
I had Devin Lynn as the victim.
And I got the co-defendant, Corey. There's a co-defendant. Okay, it's Corey Woods. Thank you, counsel. You have, I mean, you got all these other cases, but you'll have an ankle monitor supplied for by the county with a 24-hour curfew, court, lawyer, medical. You have an address where he's going to be living?
Yes,
So-
Judge. That's, I read it, it's 2000, 1 second, I lost my paper. (2000) Boulder Crest Road, Southeast, apartment C2, Atlanta, Georgia, 30316.
All right. That'd be a 24-hour curfew. $100,000 good bond. Best of luck to you, sir. You can leave the booth. Thank you for being patient, Mr. Herrick. Enjoy the football game.
Judge, is there a work exception allowed in that?
Ms. Amjad, you okay with work exception?
Um,
I don't see how he's gonna, I mean, he's got all these other cases. I'm sure there's probably,
Your Honor, if there's a work exception, if he can just notify.
all right. So he can also work as long as he, proof of employment schedule, name of the place he'll be working, the location he'll be working. He has to submit that on a weekly basis or daily basis or whatever however he gets to schedule something. All right.
He's on probation, Judge. That would just punish me.
Well, I mean, he's got to let the state has to know where he's working. So he can let the state, he can file it all the time with the clerk's office, but the state's got to know where he's working. And the ankle monitoring company, if not, they're going to do a revocation of his probation. So you got a paralegal, put your paralegal to work. Best of luck to you, sir. We got Kevin Washington. Have a good evening.
Thank you.
All right, Ms. Rondon. All right, 21 is position 21, 22 CP 212616. Kevin Washington, 108 days without indictment. Armed robbery, aggravated assault, possession of a knife or a firearm during the commission of a felony. As of September the 24th, there is no bond. Pre-trial.
Judge, in regards to Washington, multi-state offender, one in Georgia, since New Jersey, 14, and Pennsylvania, 2013 fraud, 2013 theft, 2017 theft. Nothing further.
All right, go ahead, Ms. Rondon.
All right. Okay. Before you is Mr. Washington. He is 35 years old. He has been in Atlanta for the past 2 years. His mother and father live here, and he does have a good address on file. It's 1000 Lake Regency Drive, apartment 2214. He would be living there by himself. He is a high school graduate and does have 3 children, ages 5, 8, and 10. Before he was incarcerated, he was working as a truck driver with Construction Resources. He had that position for 8 months, and it is my understanding that he could get this position back upon being released. I didn't hear any violent previous arrests, and I also didn't hear any failure to appears from Madam Pretrial. And so we would please respectfully ask this court to set bond in this case not to exceed $40,000.
All right, Ms. Amjadi.
Your Honor, looking over the court's prior bond order from first appearance, which declared no bond, I see that there were 6 victims in this case.
I think so, yep.
Given that, I understand the court's reasoning that the defendant poses a significant threat or danger to the community. Typically with cases where armed robbery, aggravated assault are alleged, those are cases where there tends to be a greater risk of harassment or intimidation to the victims. Given that and our defendant's criminal history, which actually not very substantial for the state of Georgia. We have 2 Georgia arrest cycles, but we do have some in other states. The state's position is, given that the defendant is legally entitled to a bond at this time, a reasonable bond would be one no lower than $50,000 for the armed robbery, no lower than $20,000 for the aggravated assault, and no lower than $25,000 for the possession of a firearm during commission of a felony.
All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 3495 Buckhead Loop Northeast. Ulta Beauty is the name of the store. No further contact with Shatima, last name Brown. No further contact with Amari, Amari Holmes. Amina, Amina Hughes. Mimi Arnold, Mimi Arnold. Angel Arnold. Tina, Teanna Mitchell, and Simona Mitchell, Simona Mitchell. Have an ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical. You need work, Miss Rhonda?
Yes, we would ask for the work section.
Employment and pharmacy supplies, name of his employer, schedule, the exact location he's going to be working, and proof of employment. Also, no further contact. There is a co-defendant here, I think. One second, it's popping up. Oh, okay. The co-defendant is Shatima, Shatima Brown. That's the co-defendant. The first name I called off, Madam Clerk. So we'll do 30, 30, and 20. 30, 30, and 20. Best of luck to you, sir. You can leave the booth. Martez Dukes. Martez Dukes, wave your hand.
Your Honor,
Yes, ma'am.
that does conclude my business tonight. May I be excused?
Yes, ma'am. Have a good evening.
You as well.
Martez Dukes.
Your Honor, are they going to bring Mr. Dukes up?
LT, we got, let's see who's in it. Mr. Dukes. Is there a
I think
Duke
that's,
here? Is that him?
yeah,
Okay, this
in
is-
North 5.
All right, there he is.
All right.
All right, it's position 22, Boston, 22, CP 211. I'm gonna put you on mute because I hear some feedback.
All right.
That's okay. 22 CP 211001 Martez Denard Dukes, 167 days without indictment. There is a $217,500 good bond. As of July the 28th, 2022, aggravated assault, possession of firearm during the commission of a felony, possession of marijuana with intent to distribute, possession of cocaine, possession of MDMA, possession of MDMA, possession of Schedule 4, possession of Schedule 2, possession of Schedule 2, theft by receiving stolen property. Trial.
Judge, in regards to Mr. Dukes. 1 South Carolina, 14 Georgia, 3 FTAs, 2014 felony convictions, criminal attempt to commit a felony, 2014. Nothing further.
All right. Go ahead, Mr. Jerome.
Unmute.
You're on mute. You're on mute.
All right. Yeah. So as you noted, Mr. Dukes has a bond. It's $217,500. It's just a bond that he can't reach. And so we're asking for a bond reduction. He has 10 charges, 9 felonies, 1 misdemeanor. He has an aggravated assault that is really questionable because Mr. Dukes was not involved. There was a gunfight, and Mr. Dukes was not involved in that gunfight at all. He had pulled his weapon because he was with his fiance and his children, but he didn't shoot anybody. He just pulled his weapon for his own protection. And then for whatever reason, they included the aggravated assault, but he was not involved in that gun battle. No one has testified that he was, and he was actually one of the witnesses when the police came. He was actually one of the witnesses that described the scene and what had happened. And then at a later time, they reviewed, I guess, some video, and they seen that he had his weapon pulled, and then they charged him. And they came to his room. They searched his room without a warrant. I don't want to get into the facts of the case too much. However, it's mainly just a drug possession. We believe that aggravated assault won't even get indicted when the DA looks at it. And he just can't afford the bond at $217,500. He's missed Christmas with his family. He has children and he has a fiance, and his mother lives here in Georgia, and he's going to be living with his mother. He's obviously been incarcerated since July, so he's lost pretty much all means of income at this point. He's had financial issues. So we're just asking for a very reasonable bond here. In terms of the aggravated assault, we're going to ask for a $10,000 bond. In terms of the theft, we're going to ask for an OR bond. And in terms of the 8 possession charges, we're asking for 5,000. So in the aggregate, it would come out to 50,000 altogether. And he's willing to submit the pre-trial services or any other assurances the court may need in order to assure his appearance.
Ms. Amjadi.
Your Honor, with respect to the aggravated assault and firearm charges, at this point, I don't have any evidence that indicates that those are unreasonable bond amounts, so I would respectfully request that those remain the same, particularly as they're not very high bond amounts given the nature of those offenses. I am taking a moment to cross-reference the Judge Brasher's standing order with the warrants to see if the bond amounts there are reasonable or in compliance with that order. If not, perhaps we could reduce those bond amounts as provided for by that standing order. Your Honor, unfortunately, it does not appear that there are weights or quantities provided for in these warrants.
Right.
Your Honor, given the lack of specific information within the warrants, I'm not sure what would be appropriate with respect to changing the amounts of the current bond amounts for the drug charges.
Okay.
I will defer to the court.
Okay. No drugs unless prescribed, no alcohol, no weapons. No further contact with co-defendant Alfonso Chapman, Chapman. No further contact with Jamarcus Spear, Spear. Stay away from 6701 Shannon Parkway in Union City. That's the Garden Inn and Suites. Forget that. You're gonna have an ankle monitor paid for by the county with a 24-hour curfew, except for court, lawyer, and medical. I'm sorry, Mr. Did you say what address he'd be staying at? Is that?
He's going to be staying in College Park. I can put the address in the chat.
All right, yeah, just file that change of address with the clerk's office. That'll be that ankle monitor, be 24-hour curfew, court, lawyer, and medical. So let's see, position. Okay, count 1, 10,000. Count 2, 2,000. Count 3, 15,000. Count 4, 15,000. Count 5, 15,000. Count 6, 15,000. Count 7, 15. Count 8, 15. Count 9, 15. Count 10, 5. So it's 10, 2, 15, 15, 15, 15, 15, 15, 15, and 5. Madam Clerk, you got that?
Yes, Your Honor.
All right, thank you. Best of luck to you, sir. You can leave the booth.
All right, thank you, Your Honor. May I be excused?
Yes, sir. Have a good evening.
You too.
All right, DeMorris Nichols. DeMarcus Nichols, sorry, DeMorris Nichols, 26. That's 22 CP 213013. 94 days without indictment. Right now, there's a $3,000 split bond. Possession of marijuana, more than an ounce. Possession of firearm by a convicted felon, theft by receiving stolen property. It's a firearm. Right, wait a minute. There's 2 cases. 27. 22 CP 213014. Battery, family violence, and aggravated assault. Raw.
Judge Nichols, 18 prior arrests. Open case, 19 SC 166221, Schedule 2, 19 SC 166745, MDMA, marijuana with the intent, Schedule 2 with the intent to distribute. 2 arrests for probation violations, FTA 2022, open case 22 CR 00675, IJ, simple battery family violence convictions, 2016, purchase, manufacturing, sale of marijuana. Nothing further.
All right. Go ahead, Mr. Melnick.
Thank you, Judge. Good evening. So Mr. Nichols is 32 years of age. He'll be living at 3280 Spanish Trail in East Point. The alleged victim in this case is Jasmine Eccles. I cannot be quite as, I've spoken with Ms. Eccles, and I know that she is not opposed to bond, but I don't know that I would be able to get her on this call tonight. This is not a case involving a firearm. It is a aggravated assault that is really more like a family violence battery from my view and my reading of the warrants. He has now, of course, been in jail for over 90 days, and he is entitled to a bond as a matter of law. He's lived in Atlanta his whole life, Judge. He has multiple family members, including his sister and his mother that live here. He has a stable place to stay once he gets released from custody. With regard to the and the incident itself, Judge, I think it took place some time ago. I don't remember the exact date on it now because I'm not actually looking at the warrants. But it happened quite a while before Mr. Nichols was arrested. And as I understand it, Miss Eccles, the victim, continued to try to contact Mr. Nichols and has expressed to me that she does not wish for him to remain in custody. So yeah, anyway, Your Honor, I'm asking that you grant a total bond in the amount of $15,000 on the ag assault battery. And I'm asking that you give him a $5,000 bond on the firearm charge.
Yeah, it looks like the incident date was August 26th. Ms. Amjadi.
Thank you, Your Honor. I will be covering this for Mr. Whitenauer. He indicated that position 27, that was an October 30th, 2019 incident for punching the victim, Zakiya Harris, in the back of the head and then kicking her while she was down. He was arrested on October 6th of 2022. And at that time, he had a stolen firearm, a Glock within arm's reach. He was denied bond by the court on October 8th of 2022. He has a pending case in the Superior Court, 19 SC 166745 for possession of MDMA and possession of marijuana with intent to distribute. He also has position 26 on this calendar and a probation warrant for 17 SC 153683. Additionally, there is a conviction in 16 SC 146350. On the basis of the defendant's criminal history, the number of pending cases, and the nature of the offenses involved, the state's position is that we cannot consent to a bond in this matter.
I think they've both been 94 days, so you just want me to go?
I do understand that the defendant is legally entitled to bond at this time, Your Honor. I would respectfully request that any bond the court grants in the domestic violence matter, the aggravated assault, be no lower than $25,000. Thank you.
All right. On position 26, no drugs unless prescribed, no alcohol, no weapons, no further contact with Roderick Fedd, F-E-D-D. You have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, and medical. So I've got 2,000 on count 1, 10,000 on count 2, and 5,000 on count 3. Position 27, no drugs unless prescribed, no alcohol, no weapons. Stay away from 1871 Plaza Lane Southwest. No further contact with Jasmine Eccles. And Mr. Melnick, if she gets in touch with the victim's advocate, etc., we can make changes there. Ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, and medical. So you need an exception for work, Mr. Melnick?
Please, Your Honor, and I'll notify pretrial.
All right. We put an exception for work on them. Madam Clerk, proof of employment, schedule, location of employment. Does that say schedule, location of employment? No, and name of employer, all that has to be provided to his attorney. They'll provide it to the state. We can put that on both of them. Right, 15 on count 1 and 20 on count 2. Best of luck to you, sir. You can leave the booth. I think that's it, Mr. Melnick. Thank you.
Yeah.
Thank you. I know everybody's got to go get to see the football game.
Take care. Have a good night.
All right.
Thank you.
Anything else? Thank you, Miss Gandy.
Judge, Lieutenant wanted me to let you know
Welcome,
he had to
Your
get
Honor.
off
Thank
the
you.
call because he had to handle something at the jail.
Oh, okay. That's fine.
Have a good evening, Your Honor.
Thank you. Miss
Thank
Cassidy.
you, Your Honor.
stop- Thank you. Can you stop the stream, Miss Cassidy?
Judge, now you the one not paying your utility bills over